Hello, everyone. Welcome to today's webinar, Chemicals Quarterly Q4 2025 Regulatory Update. We are happy to have you here. Let's see. Sorry, one second. Let me get my... So we have some... Sorry, I'm so sorry. We are just getting my bearings here. Okay. So my name is Carrie Whalen. I am the Product Marketing Manager at Compliance and Risks, and we are joined by the wonderful Kim Plashy, Regulatory Content Specialist in Content Research and Development. Kim is a Senior Regulatory Content Specialist on the Content Research and Development team, specializing in international product safety regulation, with a strong focus on chemicals in products and environmental regulation. She stays at the forefront of the evolving regulatory landscape. Kim holds a bachelor's degree, Bachelor of Science degree in Environmental Studies and a Master of Library Science, both from the University of Buffalo. Before joining CNR, Kim gained extensive experience in university, public and private libraries, and she's also a published author with articles and research contributions featured in peer-reviewed journals and academic texts. And additionally, Kim has a significant experience in the consumer products testing industry. She's provided research and technical support for both internal testing teams and external clients. And Cassie Parshin, she is our regulatory expert, MLS Senior Regulatory Content Specialist. Cassie is a Senior Regulatory Content Specialist on the Content and Development team, responsible for creation and management of essential regulatory information. A librarian by training with 16 years of experience in the consumer products industry. She specializes in global research for our clients across the supply chain. She's based in Buffalo, New York, and currently enjoys a focus on product labeling and chemical restrictions, as well as her participation in ASTM standards development. And I'm Carrie Whalen. I'm a Senior Product Marketing Manager here. Okay. So before we kick off the webinar, I'd like to provide you some background about compliance and risks. For those who are joining this series for the first time, at Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are a trusted compliance technology provider for the world's leading brands. We've spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape and prove your product's compliance, protecting your brands and helping drive your growth. At Compliance and Risks, we have the world's most comprehensive regulatory database with over 100,000 regulations, historically available in C2P. With a global regulatory coverage and expertise across 10 countries, we understand that regulatory compliance does not sleep. Our regulatory experts team is truly global, with 28 languages collectively spoken across the team, and we are fortified by 30 knowledge partners. C2P is our enterprise software. It is designed to keep global organizations on top of regulatory change and their impact worldwide. This includes early warning alerts and impact probability, productivity workflow tools, and so much more. But with that, I'd like to hand it over to you, Kim.
Okay. Thank you so much, Carrie. Happy to have you joining us for the first time, and welcome to everyone that is returning for our Chemicals Quarterly webinar series. By now, you're probably used to how we're doing this. I'll start us off on the western side of the globe before I hand it off to Cassie. And we are actually starting off right in North America. We don't have much from South America this quarter, but we are hearing from a country that we don't normally get news from, and this is Panama. The country has significantly tightened its grip on cosmetic safety through their resolution number 218. This applies to products containing trimethylbenzoyl diphenylphosphine oxide or dimethylethylamine. The National Directory of Pharmacy and Drugs has been empowered to immediately revoke sanitary registrations for these products, which means that any product that is currently on the shelf containing these chemicals is now legally unmarketable in Panama. The resolution was published on October 29th, but retroactively entered into force on October 22nd. Manufacturers and distributors had a hard 30 business day window from the publication date to submit a detailed report on their recall efforts at that time. The Mexican Secretariat of Health is moving to harmonize its lead in paint regulations with international standards through the introduction of a new draft standard, a draft mandatory standard. This draft NAM is a significant evolution from previous iterations. Specifically, it codifies the 90 parts per million limit for total lead content. This threshold applies to the weight of the total non-volatile portion of the product. If this is enacted, the standard will be mandatory throughout the country and applies to any person engaging in the processing, importation, or commercialization of covered products. Beyond the concentration limits, the draft also introduces labeling requirements that are designed to ensure that any remaining risk is transparently communicated. Comments on this draft were due December 30th. Heading up north for some news from the United States, starting at the federal level. On November 13th, the EPA proposed a rule that is a pivot in the TSCA Section 8A7 PFAS reporting landscape. While that original 2023 rule that we've all been watching was broad, this new proposal seeks to harmonize the regulation with existing chemical data reporting frameworks. The most impactful change is the proposed exemption for imported articles. I know this is something we've been asked about quite a bit. The move by the EPA now addresses the immense technical and administrative challenge of retrospective data collection from international supply chains. By removing article importers from the scope of the requirements, the EPA estimates that over 127,000 small businesses will be relieved of reporting obligations entirely. Furthermore, the EPA is introducing a 0.1% de minimis threshold for PFAS in mixtures and articles. Previously, any detectable amount was reportable. This change, along with listed exemptions for impurities and more, allows the agency to focus data collection on the most commercially relevant volumes. Now, regarding the timeline, there are two critical shifts. First, the EPA is proposing to shorten the submission window from 6 months to 3 months. So this means that while the scope has narrowed, so also has a time frame to submit. Secondly, the submission period is no longer tied to a fixed date like the previous April 2026 extension was. Instead, it will trigger 60 days after the final rule's effective date. The structural definition of PFAS isn't changing, and the look-back period remains the same, January 2011 through December 2022. For those that are still required to report, the known to or reasonably ascertainable standard remains the legal benchmark for due diligence. Slides aren't, hopefully you all see the same slide as me now, the water bead slide. If you don't, just shout in the chat. The U.S. Consumer Product Safety Commission is transitioning water bead requirements from the previous voluntary ASTM standard to a rigorous mandatory federal rule under 16 CFR 1250. The rule is effective March 12th and addresses critical gaps in the previous chemical safety protocols. What we're seeing here for chemicals are specific limits for acrylamide monomer. When the industry, they previously relied on general toxicity standards, but now the CPSC has found hazardous levels of extractable acrylamide in existing products. The new limit of 325 micrograms per testing unit is based on acute oral acceptable daily intake of 0.05 milligrams per kilogram per day. That addresses the neurotoxicity hazard that occurs following ingestion. Regarding labeling, the warning content has been strengthened to be more conspicuous and permanent. Strategically, the rule adopts a broad definition of liquid absorbent polymer to prevent manufacturers from bypassing the rule by using liquids other than water for expansion. Toys that contain beads, such as sensory squeeze balls, are also now fully in the scope. So if a child can bite into the toy and access those beads, they must meet the rule's size and chemical requirements. Moving on to the states, California continues to lead the United States in cosmetic ingredient reform by aligning more closely with EU standards. This quarter, we're looking at two distinct pieces of legislation that were enacted. First, Assembly Bill 60, the Musk Reduction Act, was signed on October 7th. This one targets synthetic nitromusks, which are known to be persistent and endocrine disrupting. By January 2027, 4 specific musks, namely ambrette, tibetine, masking, and xylene, are completely prohibited. For musk ketone, the law shifts from a total ban to a tiered concentration limit. While fine fragrances have a 1.4% ceiling, oral products do now have a zero tolerance policy. Second, we're looking at SB 236, or the Combating Unsafe Relaxers or Curl Act. This one addresses longstanding health equity concerns regarding hair relaxer products. The bill isn't just an ingredient ban, but a larger enforcement framework. First, by January 1st, 2028, the DTSC will publish the specific lab methods to prove compliance, but the full weight of the law hits in 2030. By January of that year, DTSC will have its regulations finalized, and by July 1st, 2030, all manufacturers must register their relaxer products and pay required fees into the Act's fund. On September 19th, California's Office of Environmental Health Hazard Assessment moved to formalize no significant risk levels for 1-bromopropane and diethylamine. For 1-bromopropane, the proposed level is 54 micrograms per day, and this is relevant mainly for industrial applications. More relevant for our attendees today is a proposal for DEA. OEHHA proposed a dermal-specific NSRL of 6.4 micrograms per day. Historically, the chemical has been a source for litigation because it often occurs as a trace contaminant in triethylamine or other surfactants. Without a state-sanctioned safe harbor, companies are required to either provide a warning or fund independent toxicological studies to defend against those notices. The comment period closed on November 7th, and it saw a significant pushback from trade groups like the Personal Care Products Council. They argue that the 6.4 microgram per day limit is overly conservative, citing the agency's interspecies adjustment for dermal absorption that doesn't fully account for the fact that human skin is less permeable than the rodent skin used in underlying studies. So we will keep tracking this one to see what happens with these proposals. As of May 2025, OEHHA added vinyl acetate to the Prop 65 list. Under the standard 1-year transition period, the requirement to provide clear and reasonable warnings for exposures to this chemical are now in effect. Vinyl acetate is a foundational component in many consumer goods, primarily used in the production of polymers and copolymers. Key materials identified by the agency include polyvinyl acetate and ethylene vinyl acetate. OEHHA recently issued an informational letter to clarify expectations regarding the 60-day notice process and associated testing protocols. They have specified that any party issuing a notice must include factual information to establish the basis for it. Regarding analytical methods, the guidance emphasizes exposure-based testing. While determining the total amount of vinyl acetate present in a product is considered useful, the priority is to determine the amount of the chemical released from the product during intended use. Specifically, the agency advises against using test results obtained by dissolving vinyl acetate containing polymers in ways that do not reflect normal use, storage, or maintenance. Finishing up California with some last news for Prop 65, in December, OEHHA significantly updated the list impacting two high-interest chemicals through the state's qualified experts mechanism. First, looking at bisphenol S, commonly known as BPS. While this was initially listed for female reproductive toxicity back in December 2023, OEHHA added it as a male reproductive toxicity endpoint on January 3rd, 2025. More recently, on December 5th, the developmental toxicity endpoint was added for BPS. This follows the determination by the Developmental and Reproductive Toxicant Identification Committee that this chemical clearly causes developmental harm. Just a reminder that the warning requirements for the initial BPS reproductive listings took effect at the end of 2024. Next, we have N-methyl N-formylhydrazine. This substance was added to the list as a carcinogen effective December 8th. This decision stemmed from the Carcinogen Identification Committee meeting held on November 18, 2025. During that session, the committee reviewed evidence compiled during a data call-in that began in late 2024. After reviewing the documentation and considering public comments, the committee voted 8-1 to list this substance. Under Prop 65 rules, businesses have a 1-year transition period before the warning requirement for significant exposure becomes legally enforceable on December 8th, 2026. As we all know, in 2024, Connecticut enacted their PFAS and products law starting July of this year. Specific product categories containing intentionally added PFAS cannot be sold or distributed in the state unless they bear a disclosure label. That requirement remains in effect until the state transitions to a full product ban on January 1st, 2028. An order issued last quarter formalizes approved wording for these labels. To remain compliant, companies must use one of the phrases that I've listed on our slide here. It is important to note that if a regulated category is used as a component in a larger product, the final product must also carry the label. Labels are required for the categories covered in the broader PFAS and products law and listed on the slide here. Organizations may seek to use symbols or alternative language that is better suited to their packaging or their branding, but there is a petition process for this. Petitions must be sent to the department's dedicated PFAS email address and include the proposed text or symbol along with contact details. The department intends to maintain a living list of these approved alternatives on their PFAS and products webpage. Bill S2660 was introduced in Massachusetts in November. This legislation replaces the earlier S195 and establishes a robust framework for managing chemical risks. The most immediate impact would be a proposed prohibition of intentionally added PFAS. Under Section 6 of the bill, the sale of any children's product or component containing intentionally added PFAS would be prohibited starting 1 year after the effective date. Note that PFAS is broadly defined here as any organic chemical containing at least one fully fluorinated carbon atom, and the Department of Environmental Protection will set total organic fluorine thresholds for measurement. Beyond PFAS, the bill creates a 2-tiered list system. We've talked about this quite a bit for previous proposals from Massachusetts. Within 18 months, the department, in consultation with the Toxics Use Reduction Institute, will publish an initial list of chemicals of concern and high priority chemicals. The department does have the authority to adopt New York's COC list and Oregon's HPC list directly to expedite that process. Once a chemical is listed as a COC, manufacturers have a strict 180-day window to report its presence to the state via the clearinghouse. The report must include required information such as the CAS number and the specific function of the chemical in the product. The strategy for high priority chemicals is even more aggressive, with a 3-year deadline for the mandatory substitution of the chemicals in high exposure categories, such as mouthable toys and cosmetics. By the 5-year mark following the listing of a high priority chemical, a total sales ban would take effect unless a federal preemption or commissioner waiver is granted. The Minnesota Pollution Control Agency has officially finalized their administrative rules for PFAS reporting under Amara's law. On December 8th, the agency confirmed a 6-month extension for the initial reporting deadline. Instead of the original January date, manufacturers now have until July 1st of this year. The extension is specifically intended to give teams enough time to formalize supplier disclosure agreements, as well as navigate the new digital infrastructure. Speaking of that infrastructure, the MPCA is utilizing a new platform called PRISM. A soft launch for a select group of manufacturers occurred in December, and the portal is becoming available to the broader manufacturing community throughout this month. For reporting, the final rule offers several practical concessions that were advocated for during the rulemaking process. Manufacturers are now permitted to report PFAS concentrations and ranges rather than exact amounts, and they also have the option to group products that share similar PFAS functions and chemical compositions. Regarding the ongoing schedule, once the initial July 1st, 2026 deadline is met, the state will move to an annual update cycle. Any new products containing intentionally added PFAS introduced to the Minnesota market must be reported by February 1st of the following year. Some news from New Jersey's attempts to regulate PFAS, starting off with Senate Bill 4798. Please note that I do have a typo on our slide here. The correct bill number is 4798, not 4978. This was introduced in November and saw committee amendments in December. It creates a strict prohibition on intentionally added PFAS in apparel. The definition of apparel here is broad, and it covers everything from undergarments and school uniforms to diapers. It is important to note that this bill provides a 2-year buffer from the effective date, and exemptions would include items like personal protective equipment. Moving on to the broader legislation, S 1042 successfully passed both houses and was actually enacted by the governor on January 12th, just a few weeks ago. This is a massive regulatory shift for New Jersey. It doesn't just focus on apparel like the other bill, but it targets several high-risk consumer categories. Specifically, it targets cosmetics, carpets, fabric treatments, and food packaging containing intentionally added PFAS. Similar to that apparel bill, the compliance deadline doesn't take effect until 2 years following the effective date. For those in the houseware sector, there is a specialized labeling requirement for cookware to be aware of. If PFAS is present, the product must feature disclosure labels in both English and Spanish. New Mexico is moving forward with the implementation of the PFAS Protection Act through the proposed rule NMAC 2013-2. This rule is slated to take effect on July 1st of this year. Before then, there will be an evidentiary hearing before the Environmental Improvement Board slated for February 23rd through March 6th. And stakeholders must submit formal comments regarding labeling and rule structure by March 31st. The first wave of sales prohibitions hit on January 1st, 2027, including cookware, food packaging, dental floss, and juvenile products. A second broader wave follows in 2028, including textiles, cosmetics, and furniture. By 2032, the state will move to a blanket prohibition on all products with intentionally added PFAS unless a CUU or currently unavoidable use designation is secured. The application deadline for CUU status for that first phase of banned products is October 31st, 2026, and the department expects to issue determinations on these by March 1st, 2027. On the reporting side, manufacturers must submit detailed product data and a $2,500 initial fee by January 2027, and failure to report by 2028 results in an automatic distribution ban. New York Assembly Bill A1797 was enacted on November 21st. It mandates specific hazard labeling for hair relaxer products containing carcinogens or reproductive toxicants. The law applies to the final manufacturer, but importantly, it does hold importers or first domestic distributors liable if the brand owner lacks a U.S. presence. The disclosure triggers are tied to specific authoritative lists, which I've listed on the slide here. Mandatory warnings must be clear, conspicuous, and printed in at least 12-point font. The statute does provide verbatim language for 3 scenarios: cancer warnings, reproductive harm warnings, or products. For both hazards being present, there is a combined statement available as well. The Act takes effect on May 21st, 2027, giving an 18-month transition period for manufacturers to reformulate or update packaging. In November, the Washington State Department of Ecology officially adopted amendments to Chapter 173-337 WAC under the Safer Products for Washington program. The rule establishes 2 distinct regulatory tracks for PFAS and 12 consumer product categories. Before I continue detailing what's happening here, I do want to note that the dates on the slide are inverted. The product bans begin in 2027, but the reporting requirement has already started in 2026. So for the restriction track, this targets apparel and accessories, automotive washes, and cleaning products. For these categories, the manufacture and sale of products containing intentionally added PFAS will be prohibited in the state. Those restrictions apply to both physical and online sales channels. The reporting track covers 9 categories where restrictions are not yet in place, but transparency is now required. This includes high-performance items like apparel for extreme use and footwear. Between the proposal phase and the final adoption, Ecology introduced a de minimis threshold. A concentration of total fluorine exceeding 50 parts per million is now the official benchmark used to presume the intentional addition of PFAS. This provides a measurable standard for testing. We also saw refined definitions for extreme and extended use and cleaning products to clarify that restrictions do not apply to certain pesticidal products or industrial applications. Regarding the timeline, the rule became effective on December 21st, and this gives a very narrow window to prepare data systems, as a requirement to identify and track products began in January. The first formal reports are due to the state by January 31st, 2027, covering 2026. And that is that hard prohibition date as well. Finishing up further north, in October, the Canadian Minister of the Environment issued 2 ministerial conditions imposing strict controls on the manufacture and import of 2 specific substances, which I've listed on the slide here. For both of these, notifiers must provide a comprehensive technical dossier to the minister at least 120 days before domestic manufacturing begins. This must detail things like annual volumes, facility locations, environmental release points, and disposal protocols. All compliance documentation must be maintained in English or French at the Canadian place of business for 5 years, and these records must be updated within 30 days of any change in case of an audit. The conditions for these, the dates for these entered into force retroactively on October 2nd and October 23rd, 2025. On December 31st, the Government of Canada issued the Prohibition of Certain Toxic Substances regulations. This legislation update completely repeals and replaces the 2012 regulations, consolidating requirements into a simplified framework to streamline industry compliance. The most important expansion is the new prohibition of 2 flame retardants, DP and DB-DPE. These are now restricted along with any products containing them. Additionally, the 2025 regulations tighten restrictions on chemicals such as PFOS, PFOA, HBCD, and PBDE. Many exemptions previously allowed under the 2012 regime have been removed or narrowed to meet the objective of reducing environmental concentrations. The regulations enter into force 6 months after their publication in the Gazette. Parties must be aware of the strict 30-day window following the coming into force date to apply for permits. To qualify, applicants must prove that no technically or economically feasible alternatives exist and provide a clear compliance plan for transitioning within 3 years. Several orders were published last quarter to amend the domestic substances list and non-domestic substances list. We don't have enough time to cover every substance and restriction today, so I have included the citations on the slide so you can refer to those later. The DSL is Canada's inventory of substances manufactured in or imported into the country on a commercial scale. When a chemical is added officially to the list, it is considered existing and generally does not require a new regulatory assessment before use. Conversely, the non-DSL contains substances that are not widely used in Canada but known to exist elsewhere. These listings are mainly based on the US EPA's chemicals inventory. These substances are considered new to Canada, and importing or manufacturing them may require notification and risk assessment, though they often have fewer data requirements than substances that aren't listed at all. So that is all for the western side of the globe. I will now pass it off to Cassie to start us off with Australia.
Thank you, Kim. Hello, everybody. I have just about as much to cover in my half of the world, so I'm going to hop right into Australia. On October 14th, the Australian Industrial Chemicals Introduction Scheme initiated a formal evaluation of 522 PFAS listed on the Australian inventory of industrial chemicals. Mandatory notices are being issued to all businesses registered as chemical introducers between September of 2023 and August of 2025. They launched this data collection to confirm which of these specific PFAS are being imported or manufactured, the total volumes entering the Australian market, and their specific end-use applications. So information will ultimately help the government determine which chemicals require further high-priority risk assessments and stricter management. Businesses receiving these notices are required to provide detailed information, including cast numbers and names, volumes, and if listed PFAS were imported or manufactured. If a registrant is unable to provide certain details, they must give formal reasoning for the missing date. And that's it for Australia. They were pretty quiet last quarter, but Europe was not, of course, so we'll hop in there. Council Decision 2258, adopted on October 31st, defines the position of the EU for the 6th meeting of the Conference of the Parties to the Minamata Convention on Mercury. This is also known as COP6. So the primary purpose of this decision is to authorize the EU's support for proposed amendments to Annexes A and B of the Convention, and these target the reduction and eventual elimination of mercury use in various products and manufacturing. Specifically, the EU position supports setting new phase-out dates for mercury-added products listed in Annex A, such as certain lamps and measuring instruments, and then further restricting industrial uses under Annex B that utilize mercury or mercury compounds. The legislative action is consistent with EU's existing environmental protections and aims to strengthen global health and environmental safeguards. On December 12th, the EU published Regulation 2509 on the safety of toys, and this repealed the existing Toy Safety Directive. With regards to chemicals, the new regulation introduces generic prohibitions on most hazardous substances classified under the CLP regulation, specifically targeting carcinogens, mutagens, and reproductive toxins. The scope of these bans is expanded to include endocrine disruptors, substances causing specific target organ toxicity, and respiratory or skin sensors. The regulation also prohibits the intentional use of PFAS and specific bisphenols. To ensure higher safety standards across all age groups, many limit values previously reserved for toys intended for children under 36 months are now applicable to toys to all toys for children under 14 years of age. That's quite a jump. The regulation updates migration limits for heavy metals, including lead, cadmium, and chromium, and monomers like BPA. It also mandates stricter controls on allergenic fragrances and requires manufacturers to conduct comprehensive safety assessments of combined chemical exposures. And then it also introduces a digital product passport, which you likely have seen introduced for other products in the past few years. This replaces the traditional declaration of conformity and allows for automated verification of compliance by customs authorities. And this went into effect right at the beginning of the year on January 1st. Following decisions under the Stockholm Convention, on November 21st, the European Commission published 3 draft regulations proposing amendments to the Persistent Organic Pollutants regulation. The drafts would amend Annex 1, which are prohibited for manufacturing and use, and they would introduce or update restrictions on long-chain PFCAs, medium-chain chlorinated paraffins, and chlorpyrifos. The draft establishes very low UTC limits, including 0.25 milligrams per kilogram for PFCAs, and 0.26 milligrams per kilogram for related compounds. Time-limited exemptions are proposed for specific semiconductor applications in spare parts and repairs for legacy vehicles and vessels until December of 2030. Articles already in the EU market before December of 2023 may continue to be used. The proposed MCCP amendment introduces a general UTC limit of 0.1% by weight alongside time-bound derogations for industrial, medical, aerospace, defense, and then heavy-duty applications as well, some extending until 2036 or 2041. These exemptions are accompanied by obligations to minimize environmental releases to worker exposure. Separately, the Commission proposed to list chlorpyrifos in Part A of Annex 1 without any exemptions for production or use. A strict UTC limit of 0.1 milligram per kilogram is established to support enforcement. And comments were due for all 3 drafts on December 19th. On December 11th, Latvia published Regulation 730 to form requirements for the use and labeling of equipment and products containing certain hazardous chemicals. Issued under Latvia's waste management law and pollution laws, and aligning national rules with relevant EU directives, it establishes mandatory requirements for the use, handling, and labeling of equipment and products that contain specific dangerous substances. It also sets out a list of environmentally harmful goods and their chemical. So this regulation focuses a lot on polychlorinated biphenyls and polychlorinated terphenols. These are historically used as insulating fluids in transformers, capacitors, and other industrial equipment. The text defines when substances qualify, prohibits new installations, including such equipment, and requires registration, labeling, and reporting with volumes above 5 cubic decimeters to the State Environmental Service. It sets decontamination and storage and disposal obligations, prohibits reuse of separated PCBs and PCTs, and mandates clear permanent marking on equipment and locations where hazards exist. The regulation also integrates EU battery labeling requirements for products with built-in portable and light mobility batteries. It entered into force on December 12th. November 21st, Switzerland published amendments to their chemical risk reduction ordinance. A major focus of this update is to tighten chemical restrictions and harmonize many substance controls with EU standards. The updated Annex 1 includes expanded controls on persistent organic pollutants and PFAS. Notably, PFOS, PFHXS, and PFOA are emphasized and regulated with strict limits or prohibitions. The list of prohibited POPs now include newer entries such as Declarane Plus, methoxychlor, and UV328. Separate provisions have been introduced for other PFAS like PFHXA related substances, imposing concentration limits in products such as cosmetics, textiles, leather, food contact materials, and mixtures for general use, just to minimize exposure. And then updated provisions also include a REACH style alignment on microplastic restrictions, lead content limits in PVC mixtures and articles, formaldehyde emission standards for wood products, furniture, and vehicle interiors, and updated controls on halogenated organics, ozone depleting substances, and substances subject to authorization under EU REACH. And this, the implementation for this began in phases starting December 1st. Moving on to the UK, in October, the UK Health and Safety Executive drafted a recommendation to add specific substances of very high concern to Annex 14 of UK REACH. Inclusion in Annex 14 means these substances cannot be placed on the market or used after a certain sunset date unless an authorization is granted for specific use. The three substances identified by the draft are DOTE, a reaction mass of DOTE and MOTE, and tetraethyl lead. All three are classified as toxic for reproduction. DOTE and MOTE are primarily used as heat stabilizers in PVC plastics manufacturing, and tetraethyl lead has been commonly used as a fuel additive. Comments are due next week on February 4th. The UK is also aligning legislation to the Minamata Convention with their Control of Mercury Amendment regulations. Published on December 2nd, it amends existing laws to restrict the use of mercury in various products. The amendment introduces new phase-out dates for a wide range of electrical and industrial equipment. This includes various types of fluorescent lamps, vacuum pumps, and devices like melt pressure transducers and sensors. The restriction also covers specialized items like strain gauges, tire balancers, and photographic film. Most of these prohibitions took effect on December 31st, though certain lighting products have extended deadlines reaching into 2026 and 2027. That does it for Europe. We'll pop right over into Asia. There's a lot to cover there. Starting with China, on December 26th, China's National Medical Products Administration proposed updated regulations for registering new cosmetic raw materials. Applications would be submitted through a digital service platform supported by comprehensive research reports, quality data control, and safety assessments. The proposal requires that physical samples of new ingredients be retained for reference, featuring strict labeling standards. These must clearly display the ingredients' Chinese and INCI names, the entity's contact details, production and expiration dates, as well as specific storage conditions. This draft also emphasizes ongoing compliance through annual safety monitoring reports, and these must be submitted within 30 working days before each anniversary of the material's approval. Toxicology and safety tests are expected to align with the cosmetic safety technical specifications, and that is to ensure high standards of consumer protection. The public consultation period was open until January 25th, which was just last week. On November 7th, the Chinese Ministry of Ecology and Environment released a draft announcement to align national regulations with the Minamata Convention, as well as the EU and UK. The proposal outlines a phased ban on the production, import, and export of specific mercury-added products and industrial applications. And the bans will be rolling out in 3 waves for China. So by the end of 2025, the end of last year, they targeted smaller mercury products. And this included most button cell batteries with less than 2% mercury, cosmetics and soaps, and then some high-tech industrial switches. By the end of 2026, the focus shifts to lighting. They're banning older, less efficient fluorescent bulbs, specifically the big 30-watt or higher compact bulbs, and then older halophosphate tube lights. By the end of 2027, the ban on more modern tri-band phosphor fluorescent tubes and circular bulbs will kick in. Aside from products, they are also prohibiting the use of mercury in the industrial process of polyurethane production and larger assembled goods. Exemptions are applicable for scientific research, calibrating lab equipment, and the comments were due here by November 17th. In November, China's Ministry of Industry and Information Technology proposed significant updates to the China RoHS framework. This would expand the scope of regulated products to include 28 new categories, such as smartwatches, industrial washing machines, servers, and then various other small household appliances. Newly added products would have to meet strict hazardous substances restrictions and labeling requirements by August of 2027. And then the exemption list for substances like lead and mercury have also been revised. They include an expiry date of July of 2027 for many existing exemptions and adding new provisions for recycled phthalates in medical devices. And then continuing on with that, China's MIIT and the State Administration for Market Regulation also published announcement 44 in November, and this outlines the phase transition from the old voluntary standard, which was GB/T 26572, to the new mandatory standard, which is just the GB. It's the same number, but just GB. There's no T in that designation. So between now and July of 2027, companies can utilize a combination of the old standard with its recent amendments or just the new standard. By August 1st of 2027, all EEE products must strictly adhere to the new standard. Products already on the market must also undergo conformity assessment conversions. Those using the oldest standard must convert by January 2027. And while those using the amended version can transition naturally through certificate renewals or product changes. And then on October 6th, India published a draft notification introducing amendments to their food safety and standards packaging regulations. These propose significant restrictions on chemical substances used in food contact materials. The amendment adds a total ban on the use of PFAS in the manufacturing of FCMs, and then a mandate that any FCM made from polycarbonate or epoxy resins must be completely free of BPA and its derivatives. Comments were due on December 10th. Japan has advanced significant amendments to their chemical substances control law to expand the scope of Class 1 substances and strengthen controls on persistent and hazardous chemicals. On October 3rd, the Ministry of Health, Labor, and Welfare, the Ministry of Economy, Trade, and Industry, and the Ministry of Environment jointly proposed amendments to designate chlorpyrifos, medium-chain chlorinated paraffins, and long-chain perfluorocarboxylic acids as Class 1 specified chemicals. The proposal would prohibit their manufacture and import and was subject to public comment until November 1st. The proposed amendment also introduced product level import bans for a wide range of articles containing these substances, and they are the usual list of suspects shown here on the slide. The films, lubricants, paints, water and oil repellents, and the like. Then on October 17th, the Japanese cabinet approved Order 416 to add PFHXS also to this Class 1 list. This prohibits the manufacture, import, and use of PFHXS-related compounds and bans the import of numerous products containing the substance. This includes water and oil repellent textiles, semiconductor processing chemicals, surface treatment agents, firefighting foams, and treated clothing and floor coverings. The amendment also removed the transitional exemption for 8,2-fluorotellumer alcohol, which was effective on December 17th. And then the main provisions of this amendment will enter into force this summer on June 17th. Over in the Philippines, on November 14th, a draft administrative order updating the Philippine inventory of chemicals and chemical substances was issued. Referred to as PICCS, this is the official national list of chemicals that are legally manufactured, imported, processed, stored, or used in the Philippines. This draft seeks to add 59 new chemical substances that have completed evaluation and submitted a notice of commencement, meaning they are now proposed to move from new to existing status in the inventory. Once finalized, these substances will no longer require permits for future import or manufacture, though reporting, SDS, and labeling obligations will still apply. On November 24th, Singapore Health and Sciences Authority approved amendment regulations to update the health products cosmetics regulations, which implement Singapore's obligations under the ASEAN Cosmetic Directive. Key requirements and substance updates include changes to the third schedule with the expansion of prohibited substances in Part 1. The amendment significantly expands the list of banned ingredients to include various nickel compounds, 2-chlorocetamide, and quinoline. It also prohibits certain petroleum and coal tar derivatives if they contain greater than or equal to 0.1% benzene or 1,3-butadiene. New concentration limits and usage conditions are established for ingredients like methyl N-methyl anthrolate, which is limited to 0.1% in leave-on products and 0.2% in rinse-off products. It also must not be used in products marketed for exposure to natural or artificial UV light. The regulations also update the requirements for octocrylene, which is a common UV filter. It is now limited to 9% in propellant spray products and 10% in other products. Any benzophenone occurring as an impurity or a degradation product of octocrylene must be kept at trace levels. And then for certain preservatives, the regulation mandates that they cannot be used unless the maximum theoretical concentration of releasable formaldehyde in the mixture is less than 0.1% weight by weight. Usage of certain substances like ammonium, silver, zinc, aluminum silicate is restricted to 1% in powder foundations and 2% in deodorants, which with strict limits on nitrosamine content of 50 micrograms per kilogram. And this amendment came into force on December 1st. On October 15th, South Korea's Ministry of Climate, Energy, and Environment enacted amendments to the K-REACH operating procedures. Changes focus on streamlining the registration and notification process for chemical substances, particularly regarding how manufacturing and import volumes are calculated. Under the new rules, entities importing the same chemical from multiple overseas suppliers must now report a total cumulative annual quantity, while substances destined solely for export may be excluded. And this amendment also refines the role of appointed agents representing foreign manufacturers. So these agents can now manage registration for the same substance across multiple suppliers, or assume existing registrations when newly appointed. The update establishes clear timelines for exemption applications, allowing them to be filed 30 days before a new calendar year begins, and sets a strict April 30th deadline for the annual reporting of priority control substances in products. Revised articles also clarify the verification process for test data and corporate status, ensuring that registration forms align strictly with the hazards and quantities reported. This became effective on October 15th, although a grandfather clause protects substances notified before the end of 2024 from immediate reevaluation under the 2025 standards. On November 4th, Taiwan's Ministry of Environment proposed amendments to tighten regulations on several hazardous substances to align with international standards. Key regulatory changes include designations of methoxychlor or DDT. It's also known as, I forgot to mention that earlier. Declarane Plus and UV328 would be added to the list, with DDT and Declarane Plus being banned from manufacture, import, and sale. UV328 will have new control concentrations, though products with unintentional trace amounts may be exempt. Mercury rules are being updated to align with the Minamata Convention, and tetrachloroethylene would be prohibited in cleaning agents, though existing stocks would be able to be used until fully depleted or recycled in dry cleaning machines. Comments were due on January 5th. And then lastly, on November 6th, the Vietnamese Ministry of Industry and Trade issued a draft circular providing guidance on the implementation of several provisions of the law on chemicals, with a focus on chemical life cycle management and chemicals and products. This draft clarifies requirements on classification, management of bans and restrictions by industry and field, labeling, and the content and format of safety data sheets. It also introduces obligations to maintain logbooks for prohibited chemicals, and sets out formats, timelines, and methods for recording transactions in a central specialized database. Separately, on the same date, a second draft circular was issued. This one focused on consulting certification and incident prevention and response. It establishes codes and standard forms for chemical consulting certificates, as well as forms used in the appraisal of incident prevention and response plans. It prescribes requirements for incident response drills, including content, procedures, records, and documentation. And comments were due here by November 15th. And that does it for me. I'm going to pass it back to Carrie. We might have time for a few questions here. Carrie?
Yeah, thank you. I'm so impressed you all can pronounce all those chemical names. Thank you all for your attention so far. Here's a couple of questions that we'd love to see if our experts can address. One is, how does the UK REACH differ from the EU REACH?
I can answer that one. That was from my section. So UK REACH has greater flexibility but fewer resources, and this tends to lead to a more selective approach. As these can continue to diverge, we can't really assume that an authorization in one market will cover the other anymore. This brings about the possibility of having to run two separate strategies, and that can include different timelines, costs, outcomes, and this is all for the same substance, depending on whether it's sold in the EU or the UK.
Thank you. We'll do one more question. Are there any updates about PFAS in cooking pans from California?
Okay, so yes, so when we reported on this the last webinar, the cooking pan, the PFAS regulation had been passed, or the bill had been passed and sent to the governor. But as many of us know, this was a very high-profile bill with some famous cooks that were saying that it wasn't a good idea to restrict these chemicals. So ultimately, the governor of California did veto the bill, and he cited that it would affect affordability of cooking pans for the average consumer. But we will keep tracking to see if there are similar bills proposed and then passed. But yep, that's where that one ended.
Thank you, Kim. And thanks for tuning in with us today. We hope you found a presentation helpful, and we look forward to seeing you in our upcoming webinars. You can check out our resources section on the website to stay updated and to access our latest white papers, blogs, and webinars. We have plenty of upcoming content, so make sure you keep an eye out. Our next webinar, EU Omnibus Simplification Agenda, Key Regulatory Changes for Manufacturers, is scheduled for February 11th, and we hope to see you there. Thank you, everyone.